I'd like to turn the program over to Mark Hilliard, who is the litigation section chair this year, and he is going to get us started on our program today. Mark?
Yeah, thanks, Ann. Just want to wish everybody a good day and thank everybody for joining us. You could have been everywhere or anywhere today, but we're happy that you're here with us to talk about this issue of crossover cases between civil matters of liability and criminal matters of liability. I'm going to go ahead and introduce our panel real quick. You've got Adam Wilks there looking good in a tie. Adam is with the Contra Costa County District Attorney's Office in the Family Domestic Violence Unit. So obviously he brings to bear here this afternoon some great experience on the criminal side. And Mr. Dirk Manoukian is our other panelist here. And he is with the Dirk Manoukian Law in Pleasant Hill. And Mr. Manoukian has a very interesting and extremely relevant practice because he handles criminal matters and civil matters. And as you'll learn, a lot of cases that involve both issues. I'm Mark Hilliard. I'm a partner at Brothers Smith in Walnut Creek, California. I primarily practice civil litigation and business law, and I do a little bit of real estate and wealth preservation, estate planning type of work on the side as well. So the reason that this became a presentation that we were interested in giving is because I actually had a case. I'm not a criminal lawyer. I've never practiced criminal law. Certainly interested in it, but it just never really had the opportunity. And I had a case for a client who was swept up in a civil matter as a defendant that had a criminal bent to it. And I, not having any experience, really had to kind of learn a little bit about the criminal process and how these two types of liability kind of juxtapose one against the other. So it was a really interesting experience for me. Adam joined our board about a year ago, I think it was, Adam, or thereabout. And given his criminal background, he and I started talking, and now we're here. So we're very excited to have everybody, and we're going to go over today really three general issues and just kind of have a discussion amongst the three panelists here. The first thing we're going to talk about are situations in which you have criminal and civil liability that can arise in a coexistent manner. So we're going to talk about where these types of cases arise. Then we're going to go into the order of events, and that is going to deal with things along the lines of, should a criminal matter be filed first? Should a civil matter be filed first? What do you do? What are the advantages, the disadvantages, et cetera, of one coming before the other? And how does that open up your client prospectively to either advantages or disadvantages in the litigation? And then finally, we're going to discuss various considerations that may arise out of a single fact pattern. These are going to be just things that you would see in any type of case where there may be coexisting criminal and civil liability. So with that, I'm going to go ahead and start kind of and talk about some of these situations where you'll see this. And let me just tell you, if you have any questions as we're presenting, I'd encourage you to go ahead and put them in the chat. I will be minding the chat as we go throughout the presentation. So if there are good questions that come up or any questions that are relevant to what we're discussing, go ahead and put them in there and I will call them out and we will get some input for you to get those addressed. Similarly, if you have any questions that don't get addressed and you'd like to ask those after the presentation, we're more than happy to stick around for a couple minutes to discuss those or however long it takes to get those answered. So firstly, where do these kind of matters kind of come up? But where do you see this? And, we were talking about this in preparation and we've identified, probably 6 or 7 different fact patterns that come up. All of these are tied together with one general overarching commonality, which is that they're crimes against persons. So you see these types of criminal and concurrent civil liability and white collar and embezzlement crimes in battery matters, where you have a civil battery that will end its simple battery in a criminal aspect or even aggravated battery, and then in the civil matter there's liability for tortious battery. Vehicle collision matters with criminal conduct like DUIs with injury or death. Police officers and other first responder cases. Sexual assault matters and dissolution family matters where you have criminal conduct, domestic violence and things of the like. So these are generally all crimes against persons, and that's absolutely where you're going to see these. So in terms of issue spotting, when a new case comes in, whether you're here as a civil practitioner or a criminal practitioner, just be aware that as an issue that these types of things can come up. So let me next move to the more of the meat of the presentation. We're going to talk about the order of the events, and let me just turn it over to you a little bit first, Dirk. Generally my understanding is that you want the criminal case to start first. Is that accurate?
It is, and good afternoon, everyone, and thank you, Mark. Generally, it doesn't have much to do with what you want. It seems to be that that's how it will happen. Normally, if there's an event, the police are going to show up before the personal injury attorney. That's true, except for like large torts out in Richmond when there's a gas leak, then it seems the personal injury lawyers show up first for that. But generally speaking, what happens, you have an incident, the police come, they investigate it, the case ultimately sent to the DA and they file criminal charges, and that occurs much more quickly than the complaining witness victim in that case would seek out a lawyer and ultimately get a civil case filed. So the normally where you see this is where the criminal case is filed first, and then often you'll see the civil case filed. But the preference would be most personal injury lawyers want the criminal case to go first and not have to file the civil case. And we'll talk about, I think, some of the reasons that complicates both the criminal prosecution as well as is a disservice to the personal injury client. When the police investigate the case, their ability to gather evidence and analyze that evidence, which would basically be what you're doing in discovery, is 5 to 10 times easier for them than it would be for some private attorney to send out an SDT to get some cell phone records and then hire an expert to do an analysis of those records. So normally the criminal case starts and they'll do 80% of your civil discovery. So normally that the civil case would not start until the criminal case resolves. I know the last thing some prosecutor wants to see is that all of a sudden their victim in a sexual assault case now has filed a civil case while that criminal case is still being prosecuted. So you would prefer that to happen, but for a variety of different reasons, you will see a civil case get filed and have an open civil docket and an open criminal case being prosecuted at the same time.
I jump in with one sort of quick caveat of, obviously what a plaintiff's side attorney might want or might prefer versus the way you're actually going to see a set of facts shake out. I would note that one exception for law enforcement or a law enforcement agency bringing a case to the prosecutor who then files the case before you have a plaintiff's side attorney getting involved. The only time that you really might see that not be the case would probably be where either there's going to be a large volume of forensic material that needs to you need to go through. And when I'm referring to that, I'm usually talking about like white collar forensic analysis. So having, you have a forensic accountant take a look at thousands of pages of bank records on the one hand, or where you have issues related to interagency cooperation, or where prosecuting or filing a case is going to require so many different agencies to do their part. For example, you might have CAL FIRE, you might have, they need to complete their investigation along with a police agency. And the number of different agencies that might get involved, that can slow down a case on a prosecutor's end to where the prosecutor can't do their job until they have all the reports in from all the different sort of agencies that might have a part to play. So that could be a scenario where a plaintiff's side attorney could actually get involved and could maybe get a cause of action or get a case filed before the DA can.
Right, and so Dirk, you highlighted a couple of advantages if you're a plaintiff's side personal injury attorney of waiting until not only the criminal matter has been filed, but the criminal matter has resolved. And in terms of the ability to use what was, effectively what was turned up an investigation in the criminal matter as a civil practitioner, they're effectively doing your discovery for you. It's also true, though, my understanding that filing a civil case early, we want to be careful about which case we're talking about, because obviously you've got criminal and civil, but filing the civil case early could actually hurt the client. Could you talk a little bit about some of the disadvantages to the client in terms of, for example, causing the victim to be open to discovery or impeachment in a way that maybe they wouldn't otherwise be if the personal injury plaintiff's attorney had just waited to file until the criminal matter had resolved?
Yeah, so you see, and I agree with what Adam is saying. I think, I will answer that question, but just to try to give the three scenarios or procedural settings where you normally see these dual issues, is there's the traditional one we talked about where the crime occurs, a complaint, a felony or a misdemeanor complaint is filed, criminal complaint, and then the personal injury lawyer goes ahead and files that case while there is a pending open criminal case. I have a case very similar to that where it was a battery causing great bodily injury. The DA's office filed a criminal complaint against my client. The civil lawyer, a few months after the criminal complaint was filed, files a civil complaint. So now you have both of those going. Another scenario is a case where, and this is a little like what Adam was talking about, the client that was involved in a motor vehicle accident in which someone died, and the police are taking a very long time to do the investigation. There is a great deal of analysis. It's an ongoing open investigation, but after about a year, the family of the deceased went ahead and filed a wrongful death case. So in that scenario, you have an ongoing active investigation, no criminal charges filed, and then a civil case filed. And then the other variation, which you do still have to do some things to deal with, is a situation where you have an allegation made, and I'm handling a case like this, where there's a sexual assault allegation made and related to a school-sponsored fraternity event. That case was investigated by law enforcement, presented to the district attorney's office, and the district attorney declined to file charges. So in that case, you have a completed investigation, a review by the prosecuting agency who decided not to file charges. There was a Title IX investigation, and they found that there wasn't any merit in the case. And then the civil complaint is filed. So you have the criminal cases in some way ran its course, although with those types of charges, your statute of limitations could be 3, 6, 10 years or something like that. So you're still, in theory, within those statute of limitations. So that's kind of the three scenarios.
How does that juxtapose with the Fifth Amendment? Let's say that you're in that situation, Dirk, and you have a case where there has been an investigation that has concluded and no charges have been filed, but you're still within the statute of limitation, period, criminally, and then a civil case is filed, and let's say that they notice a deposition. For me, I would object, and I would object under the Fifth Amendment and say that because there's still some probability of criminal action having been brought or could be brought, that my client doesn't intend to answer any questions or intends to invoke his Fifth Amendment. What would you say about that? And Adam, feel free to jump in as well. Yeah.
So in that situation, in my opinion, you still need to protect your client's Fifth Amendment interest and file, one of the cases that some people call it a PACER motion. There's a Vontae. I know it will send out those sites on those cases. And it is basically a motion saying, hey, judge, we have criminal liability here. If we were to give statements that would prejudice my client, he's got a Fifth Amendment right not to make those statements. Some of the criminal lawyers out there know it's similar to like Griffin and Doyle and some of these other cases that say, no negative consequences can flow from you using a constitutional right, exercising your constitutional right. Because if you don't give a statement, if you don't go to the deposition, you end up in a default, you end up suffering a loss of property, a loss of interest, and that's a legitimate harm. So similarly, so in that case I just talked about, the one where they've done the investigation, the DA declined to file charges, they serve him with the notice of a depot. Because we're still within the statute of limitations, I filed a motion to stay discovery against my client, knowing that the judge would probably say, hey, I don't think it's a legitimate Fifth Amendment interest because this case has already been reviewed and prosecution's been rejected. But the reason I do that is so that, and the plaintiff's counsel objected, so we had a hearing, and they basically denied my motion, granted the plaintiff's motion to compel my client's deposition, and now he's in a position where he's insulated somewhat because he's giving compelled testimony. So similar to Liebarger or Getty in the federal range, when it's compelled testimony, the courts have held you're basically getting use immunity and that those statements can't be used against you in a future criminal case. One of the concerns you have is if you're getting deposed, you may say something that is sufficient to bolster the case. Now the DA says, okay, now that we know that, we can file charges.
And
So,
Dirk, I
anyway,
jumped in on that.
just to finish,
Yeah,
so I
no,
filed that and the judge said, no, I don't think there's not a legitimate Fifth Amendment interest here, and overruled that and ordered him to answer the questions.
And Dirk, I want to give you a chance to talk a little bit more about Liebarger for people who maybe don't deal more with the civil side, and that may be speaking Greek to some people. But one thing that I wanted to talk about was, I think it goes back to the kind of lodestar principle that you talked about earlier of a plaintiff side civil attorney very often might want the sort of criminal side or the criminal investigation to lead first. I can tell you that as an attorney who handled white collar cases for my office, and dealt with what we call the special operations division in our office. I will say that I've had a number of cases that even after our review, I looked at a case and said, hey, our office is declining to file. It can still happen that afterwards, as a civil case is pending, there's no bar to a plaintiff side attorney contacting the prosecutor and saying, hey, I know you came to a conclusion on the set of facts as you had them or as you believe them to be. However, in the course of the civil case, I have learned the following. So can I please have, like a sit down conversation to explain why you have a bona fide criminal case on your hands? So I think that those concerns that you've described are very right for potential criminal issues later on as the civil case proceeds. I can say that I've seen that happen in my own in the course of my own career.
Well, and to that note, Adam, that second scenario that I discussed earlier about how there was the fatality in the motor vehicle accident, a vehicular manslaughter investigation going on that was taking too long, and after a year, the family of the deceased files a wrongful death lawsuit. And so there you have a scenario, unlike the one we were just talking about, where the government had basically rejected prosecution. There you have an active investigation that's still going on. And we had to litigate that issue because they wanted to depose my client and do all of that, answer interrogatories, production of documents. And one of the relevant things is the victim's family, the father, said in a press release that the reason he was filing the civil case is to get answers that were not obtained during the criminal investigation to hold the people involved responsible. So, and that was very relevant to the judge making the analysis on my motion to stay, because we were able to say, hey, they have come out and said that the purpose of this civil litigation is to, basically force my client to be deposed. The cops can't force him to give a statement. So they're doing what the police can't do, but they're basically acting as an agent of the law enforcement trying to get more facts to support a prosecution. So that's the exact scenario that happens there. And that's the concern. And that's what they were hoping to be able to do. So that is kind of that second scenario where there's a civil case filed and an active investigation going on. And normally in those cases, the judges seem to, as long as you have a legitimate argument, will grant those motions to stay discovery related to that defendant. And just to touch on Liebarger, you asked about.
Yeah, actually, real quick, Dirk,
Yeah, absolutely.
and Adam, I was hoping we could have a little discussion around Liebarger versus City of Los Angeles, and also the federal equivalent of Garrity, because I know that there are some civil practitioners on here, not unlike myself, who are not necessarily readily familiar with those cases, which are huge tenets in this area of the law. So if we could just briefly tell us a little bit about those cases, what they mean, and what they're why they're important here.
Yeah, and then maybe just focusing on Liebarger, which is the California version of that case law, is that in the context, and we'll use law enforcement, it applies to some other agencies, but if you have a police officer who on duty is involved in some conduct that is arguably criminal, and also then starts an internal affairs investigation and an internal administrative review, the officers investigating that internal administrative case will bring the officer in and say, hey, listen, you have to, pursuant to your contract and your agreement, you have to answer our questions about what occurred for us to make this administrative assessment. And so the officer is in the position that if he does not, if he says, no, I'm going to invoke my Fifth Amendment right, I'm not going to answer these questions, he can be terminated for insubordination. They can appeal that, and there's a whole administrative process. But the workaround that Liebarger has put in place is it says that since that is compelled testimony, as we talked about earlier, similar to having to either give a deposition or default and lose the lawsuit, the courts have basically said, if you're going to compel someone to answer a question and the threat of termination is a sufficient compelling interest, we're going to say that that testimony is immunized. We're going to say that anything he says cannot be used by law enforcement or the district attorney's office or the prosecuting agency in prosecuting you. And it's a pretty all-encompassing ban, even more than, say, a Miranda violation. In a Miranda violation, you don't give it all, or somehow it's insufficient. A defendant gets up there and says something inconsistent with his non-Mirandized or statement made in violation of Miranda. Many times the DA is going to still be able to introduce what was a statement taken in violation of Miranda because it wasn't involuntary, it wasn't compelled, it just didn't have the appropriate constitutional protections given before he made those statements. But in a Liebarger statement, that statement cannot be used for any purposes. Now, and Adam can talk about this, and I'm sure he has, when I have law enforcement clients and we're in that analysis, you have to make a decision, and it's unique to each case. But many times the prosecutor is able to get their hands on the statement. Now, in theory, they can't use it. They can't use the fruits of that statement. But obviously, it's an enormous advantage for a prosecutor to be able to see the suspect's statement, even if it's something they, in theory, cannot use.
And I would, to sort of speak to that a little bit, I could give the concrete examples. And so what we're really talking about is the scenario on a prosecutor's end in which the suspect or the defendant in a criminal case is somebody who's working in law enforcement. So imagine a crime of, it could be crime of domestic violence, or it could be a DUI causing injury, something like that. And as the prosecutor, what you're looking for going into the case is, all right, if I have any evidence of statements that a defendant made at some point, of course, that's going to be information that, as the prosecutor, you want going in before you get to trial. That's always going to be valuable. It's potential impeachment information. It's something that you can use to kind of build or to develop information to kind of contradict what a defendant might have said, if possible. So in the context of lie barter, I remember the first time I came across it, I was, learning about it on the fly. And it was a case in which I had a police officer and he hadn't made a statement on the scene. So I was really interested. I was like, well, wait a second. There's this administrative hearing and I really wanted to get my hands on that statement. I was not able to. But in that scenario, yeah, the prosecutor is barred from either using it as impeachment, to use it as a statement of a party opponent. And as Dirk talks about, you can't use the fruits of that statement, meaning the prosecutor just does not get I'd say in most, if not all scenarios, despite how inventive I might want to be in terms of trying to get a judge to release that statement to me. Lie barter is a pretty clear bar. Prosecutors do not get the statement that a defendant in a criminal case may have made in an administrative hearing as a police officer. So that's a pretty clear statement of law. And as Dirk talked about, it's even broader than the prohibitions around use of a statement that's Miranda defective.
So Adam, there's no splitting hairs here. You can't say, yes, I can't use it, but I can still use it for investigation or consider it or what have you. You can't split those hairs and judges won't let you.
No, that's true. And I've in terms of people who may have, if somebody else may have testified in an administrative hearing in the defendant's favor, there may be different applicable rules because that's not compelled testimony in the same manner. It doesn't have the same implications under lie barter.
So this is a little bit down on our notes here for today, gentlemen. But one of the things that we'd also discussed, and this is converse to compelled testimony, would be, for example, a situation in which your insurance company calls you. Let's say it's a vehicular DUI or with injury or something, and they say, hey, as part and parcel of your contract with us, you must make a statement and tell us about what happened. Obviously, it's not a state action. There's no Fifth Amendment. You can't just say, no, go pound sand. I don't want to talk to you. No, my attorney told me not to, because at that point, you're going to be found very likely you're not cooperating with insurance and you're effectively in breach of contract. And so if you gentlemen want to talk a little bit about that for a couple of minutes, insurance is a different situation, is it not?
And it is. And one of the things it is, you have to deal with that issue because that insurance policy is very often your primary, if not only, source of restitution for the criminal case. So say you have a situation where, and normally with insurance, it's going to be a vehicle involved issue. So if you have a situation where you've been in a collision, you're charged with a felony DUI causing injury, there's several $100,000s of medical bills, and you're properly insured, and your insurance policy would basically pay the restitution that you're going to be ordered to pay in the criminal case. The last thing you want to do is conduct yourself in such a way that your insurance company says exactly what you just said, Mark, is that, hey, under your contract, you have a duty to cooperate in the investigation of any claim. You're in violation of that duty. We no longer have an obligation to defend or indemnify you down the road. So, and
then no settlement money, or at least you're on your own for settlement potentially if you could have tendered it to the insurance.
Exactly. So, you always want to, as if your role in all this is you're defending someone who is involved in that motor vehicle accident and now has a criminal case, and there is either a civil case filed or a claim that's being processed, you want to do everything you can without severely prejudicing your criminal defendant clients' rights to cooperate with your insurance company. So, normally you can talk to the adjuster, explain to them the situation. They're going to want some sort of statement. On occasions, I've had clients who have given statements at the scene to the police, and that's already happened. That's already out there. And I've been able to convince an adjuster to basically, hey, let's just use that statement. In theory, all they need to know is that the conduct is covered conduct. And so if you have a statement saying, yes, I'm a permissive user of the vehicle under the policy, I was driving, how much more do you really need to know? If the facts show that I was negligent, you're going to need to be, the policy is going to be in effect. And when I'm in that situation, I'm always trying to convince the adjuster to, pay out that policy. Let's get it. It greatly benefits your criminal defendant client if you get the injured party, you get them some compensation. It helps them with their attitude. It takes a little fire out when they're coming to court and upset and asking the judge to send you to prison for 6 years. The court's always happy to hear it when you say, Your Honor, our client was properly insured. We've cooperated. They've been able to make a payment and some compensation to these folks. So it is a challenge. It is a concern. You never want those conversations recorded with that adjuster, but that's absolutely one of the problems you have to deal with is the insurance company saying, hey, you need to cooperate with us or we're not going to cover that policy.
And obviously insurance is a civil, side issue. And so if you're a plaintiff side, I'm going to say this as a civil practitioner, if you are a plaintiff side personal injury attorney, it always behooves your injured client or your allegedly injured client to plead negligence in some context so that it may be turned over to insurance because the duty to defend is broader than the duty to indemnify. So if there's any basis for coverage, whether with a reservation of right or not for the insurance company, it's best that negligence be alleged. I've had so many cases where, I get some tort and it's all intentional tort. And, it might be a business dispute where, a product has gone bad or something like that, a product case. And I say, I'll call the other side and I'll go, why didn't you just allege negligence? We could turn this over. It's not a problem and probably get you paid. But this is for some reason that the plaintiff's attorneys, they either forget or they don't know or what have you. I want to go next to, in the order of events, is section 2 part that we're talking about, to talk a little bit about resolution of cases, of civil and criminal cases. When I had the case that I brought up initially that kind of spurred this whole discussion, I was very surprised to learn that the criminal case really didn't want to resolve or couldn't resolve until the civil case resolved. I assumed that the criminal case would have to resolve before I was in a position to try to resolve the civil matter. The case in which I was involved was one in which the defendant was up for diversion, or there was some type of a leniency program in place. So it wasn't as though, it was a simple battery case. It wasn't as though he was going to go to jail for years and years or anything like that. But in talking to the district attorney and also his criminal representation, I said, are we the tail or are we the dog? And I came to learn, I was a little surprised that he said, hey, get the civil case done, and then we'll use whatever settlement has been reached in that to offset, on the criminal side, we can get something done on that side and get, probation or what have you. So maybe you guys have a little bit of experience with that we could talk about for just a couple of minutes.
Absolutely. And I could kind of take the lead on this one by talking about, I've seen both sides of that coin, and where I've seen cases in which a criminal defense attorney has probably had some communication with whoever's handling the civil case for the defendant. And, the criminal defense attorney says to me, well, hey, your offer makes sense, or your offer to resolve the criminal case sounds reasonable. However, he's on the hook in this civil case, and whatever happens in this criminal case is going to have implications in the civil case later on. And unless we know what those are, unless we sort of have a clear understanding of what that resolution is going to be, I'm not willing to resolve the criminal case at all. And so I think what they're talking about more concretely is there a scenario in which the criminal plea or the criminal resolution could have bearing on the civil case?
Yep.
And some of that depends upon the nature of the plea that's reached. One thing that's notable in criminal cases is that a defendant pleading guilty versus no contest, the two implications there being a guilty plea can be used in the civil context in many scenarios. the no contest plea does not have the same implications and doesn't trigger the same liability that a civil case might.
Hold free events.
I'll also note that for certain categories of crime, you have the ability for civil parties, or the parties in the civil case, to come into the criminal context and talk about the prospect of a civil compromise. There are a number of cases that really don't, you can't get what we would think of as a civil compromise, or we use the term like civil comp. It's not going to happen. So, for example, domestic violence crimes, crimes against children, crimes against elders, or any crime that was that had the intent to commit a felony is barred by statute. The two penal code sections that you want to look to are 1377 and 1378 that kind of describe the bounds and scope of a criminal defendant's ability to resolve a case by way of civil compromise. The case where we see it the most often, or where it comes up the most as a criminal prosecutor, is in hit and run or hit and run causing injury, those being vehicle code sections 20,002 and 20,001. And that's where you have the victim who comes into court, which is required under 1378, and says, hey, look, I'm good. I've already been dealt with in the civil case. The matter has been handled to my satisfaction, and I don't have any further need for any kind of redress. And in that case, that's the scenario in which a court can actually dismiss a case pursuant to a civil compromise.
And what happens if even there's been a civil compromise, but you have, let's say, a greedy plaintiff that comes in and goes, yeah, I got paid, but I'm still not happy. Have you ever seen that happen?
I mean, no, and so without speaking to any particular facts or any particular case, what I will say is, as a prosecutor, what am I, whether I would agree to a civil compromise in large part is going to depend not just on, hey, has somebody made adequate restitution to a victim, but also, just the egregiousness of the conduct. So that comes up a lot of times, hit and run causing injury. I mean, you can see a scenario in which I, as a prosecutor, the victim might say, hey, I'm good on this, but as a prosecutor, I could turn around and say, yeah, you may be okay, but in terms of public safety and as a public servant, I'm not okay with this. So
the state has the say. The
Yes.
state has the say, not necessarily the victim, but the victim's position is considered as part and parcel of what the state does.
Absolutely.
Okay. On more serious cases, let's say, we kind of just dealt with that. Let's move a little bit into some of these Section 3 considerations of a single fact pattern. Obviously, I'll just go over a couple of these. You've got, and you will have heard some of these already, but there are statutes of limitations, obviously, that have to be considered, especially on the civil side, where, in my understanding and preparing for this and learning about this today, tend to be far shorter than on the criminal side, where they tend to be a little bit longer. So it's more of a concern, I think, for the civil practitioner. Constitutional matters in the Fifth Amendment. We've talked about, about that a little bit today. I'll just tell you anecdotally, in the case that I had, there was a criminal case filed. On the heels of that, the civil case was filed. Again, it was a simple battery case. We got a deposition notice within about 2 months. And I wrote to the opposing party. I sent an objection, a civil objection to the deposition. And I said, look, you can take it, but you're not going to get anywhere because we're just going to claim the Fifth Amendment. And he actually, the attorney on the other side said, hey, I understand, no problem. Now, this was not a huge case of, great, major criminal issues. I mean, it was a simple battery, and, in this attorney's position, probably a justified one, but I've said all of that aside for a minute. And, ultimately he just kind of backed down. We've talked a little bit about Liebarger and some of those cases with compelled testimony. Adam, talk to us a little bit about DMV hearings and DUI matters, because obviously crimes against persons, DUI is right there at the forefront of that type of a thing. If you've got a DUI with some type of an injury or death, you have these DMV hearings. What's the import of that, or not?
Sure. So I'll say, as a prosecutor, where I see or I have the greatest overlap with civil cases that involve a DUI causing injury or DUI causing death, they're usually in the context of gross vehicular manslaughter while intoxicated. It can also come up in the context of what are known as Watson murders. A Watson murder being where somebody was advised of the risks of, or was made aware of the risks of driving under the influence of alcohol, and being made aware of those risks, usually by way of, hey, they pled guilty to a DUI before. And after that conduct, then that person goes out, they drive drunk, and then they kill somebody. So those are the cases where you see a lot of overlap with civil cases, is when you're going to have like what amounts to a wrongful death action. Now, as the prosecutor, when one thing that came up earlier was talking about a responsible or a defendant talking or cooperating with their insurance representative. I, as the prosecutor, am really interested in that information. And the reason being, it's a statement of a party opponent, right? And unlike Liebarger, that's a statement where somebody at least is saying, hey, I acknowledge I was driving the car. So yeah, I think, Mark, that's a situation where I have a lot of interest in getting access to that statement. So that way I know, hey, when I get to trial, what are the possible defenses that I'm going to be up against? I bring that up because then in the context of a DUI a DMV administrative hearing, that's a sort of it's a separate creature, and it's a creature of statute that applies to the California Department of Motor Vehicles. So an administrative hearing would be somebody has gotten their license taken because they were arrested for DUI. After that, usually with their attorney, they can say, hey, I'd like to have an administrative hearing within usually a pretty short period of time. I think the time frame is like 15 days or something after the license gets suspended. They can petition to have a hearing and explain, hey, either here are the facts, here's what was actually going on, or here's why in some other fashion I should get my license back. Now, in that context, those statements, unlike Liebarger, there's no bar to the prosecutor getting access to those statements as well. So I'm really interested in if there is a DMV administrative hearing, just like if there's a statement made to an insurance adjuster. The reason why I, as the prosecutor, want to know is because there's only a handful of defenses to crimes involving motor vehicles, one of which is, was somebody else driving the vehicle or not? So that would be my interest as the prosecutor in getting my hands on, for lack of a better word, or getting access to that material. Does that make sense?
So, yeah, absolutely. And Dirk, let me turn it over to you as a civil practitioner on the civil side. Do you, in my experience, you would want to work to the extent you can, hand in glove with the defense attorney in representing someone who may go to a DMV hearing. What would your advice as a civil practitioner? How does a DMV hearing in such a search under the circumstances that Adam just described, how does that impact the civil side of the case? It seems like this might be within the ambit more of the insurance in terms of non-compelled testimony than it would be, say, with Liebarger or a judge's order compelling a deposition. What are your thoughts on that?
Yeah, absolutely. So, you have the, as the plaintiff's attorney, you're really just acting just as Adam is as a prosecutor. You're going to want to get your hands on anything that defendant may say during that administrative hearing. And it's for that reason that rarely do we put our clients on or have them testify at a DMV hearing. Many times those occur well before the criminal case is in court or well before a civil case is filed. And so normally you do not have your client testify at the DMV hearing. You may attack with an expert or something, the blood draw or the drinking pattern or whatever it is, but you really want to try to avoid having your client make any statements, particularly statements under oath. And in that DMV hearing, there's no Fifth Amendment protection. So the DMV hearing officer can ask you whatever questions he or she wants that are generally going to be the exact questions that a prosecutor would ask you on cross-examination. So, there are certainly times where you make the tactical decision that we'll deal with whatever happens with DMV. That is only involving your license. And if it's a civil case, if it's a case involving, or a criminal case and civil case involving a death or serious injury where you're looking at, some serious criminal exposure, you're going to have to just kind of deal with the consequences and the fallout, do as best as you can with DMV, but not put your client under oath making statements about an event that, you know, the consequences of which could be 6, 8, 10 years prison.
So if you, as a civil practitioner, if you have a chance, you're going to tell the criminal attorney, the criminal defense attorney, do not put our collective client at a DMV hearing. Just let them use Uber. They don't need their license.
Yeah, I
back
know
because-
exactly. If you're
Yeah.
playing the role of the defense on the civil side, you're saying, you know, absolutely not. I mean, that's the, you know, and earlier, and we didn't really address it, you know, you'd ask the question about what ends up happening when the civil case overtakes the criminal case, or the civil case gets involved at the same time the criminal case is going on. You know, earlier you mentioned the fact that someone wanted the civil case to resolve before the criminal. I will say, in my experience, it is the reverse. Normally that's the case because the civil case can't go forward with discovery because I have brought a motion to stay that civil case because of his pending criminal case. You know, and one of the consequences is in that case I mentioned with the assault, where there was a criminal case was filed and then the civil case is filed a month later, is I brought a motion to stay the discovery of anything from my client. And the judge granted that motion to stay that discovery, but denied the motion to stay the proceedings. And what ended up happening is that we were able to go forward with civil discovery as the defendant in the civil case and do things we never would have been able to do in the criminal case. And the DA was absolutely frustrated. So we were able to depose the civil plaintiff, who's the victim in the criminal case. Obviously, you could never do that in a criminal case. And then we were able to obtain mental health records and all these other documents because they alleged emotional distress. And we were able to use the civil discovery to marshal a number of facts and documents that we never would have been able to do. So that's one of the problems when the civil attorney files that PI case and gets involved in the criminal prosecution. It isn't just, you know, the defense attorney gets to stand up in the criminal case and say, well, alleged victim, isn't it true isn't this a civil complaint where you're asking for $1 million? Isn't that really why we're here? You also create a situation where the defense gets to do all of this discovery that they never would have got to do. You know, and that's why it's so, if possible, as the plaintiff's lawyer, you always want to wait and let that criminal case run its course and then file your criminal complaint.
Very good. Let me turn a little bit to a question that I know some of my civil practitioner brethren always fret about. And it's funny, you could ask 10 attorneys about this on the civil side, just cold, and you might get, you know, 8 or 9 different answers. What is the applicability of the Fifth Amendment in civil cases? And Dirk, maybe this is, you know, right for you, since you're half of your practice is dedicated to that.
Well, it's the analysis we talked about earlier. If it is how real, how legitimate, how immediate is your criminal liability. So in the situation where there's a charged criminal case, it's
Easy.
great. You don't even, you're like, hey, what my liability is, this docket number, I'm charged with a crime. And that Fifth Amendment interest in the civil case, I have never had a situation with a pending criminal case where a judge has not granted my motion to stay civil discovery. And then you have the situation where the harder cases are the one where there's an open investigation, the pending civil case, and then it's a judgment call. Then the judge has to look at the facts and say how realistic is it, because it's a balancing test between a plaintiff's interest to be able to seek redress for the harms that they've suffered through the civil court. There's obviously some prejudice to them by not being able to be compensated and, their access to justice being stayed in the civil case. But if there's a legitimate Fifth Amendment right, then that civil interest is going to give way to that constitutional right. And so the question is, how legitimate is that interest? So like that last case we mentioned where the DA rejected the case, there was no active investigation. The judge ended up saying, yeah, if this was a law school exam and the question was, could he have potential criminal liability because we're still within the 10-year statute of limitation? The answer is yes. Practically, as I do the balancing test, I think that's such a remote concern and easy for the judge to say, because on that case, those were, sexual assaults that carried, mandatory prison and, consecutive sentencing. I mean, it's a 10-year prison term if the judge is incorrect on that. But that court balanced it out and said, yeah, I don't think he's got, there is not sufficient facts on this record to say that his Fifth Amendment rights are so legitimate that I'm going to not allow the plaintiff to move forward. And in that case, he said, no, your motion's denied, and I'm granting the motion to compel. And so you have to answer these questions despite your Fifth Amendment objections.
Let me ask you guys, I'm going to give you a hypothetical, and we'll probably try to kind of close down a little bit on this, but let's see if you guys can talk a little bit about this. Let's say that there's a person who's involved in a single vehicle accident, okay? And he is, the person sustains major injuries. Let's say they are a quadriplegic or something awful, just really bad injuries. Let's say that they live. Let's say that at the accident scene, there was a bag of some type of a controlled substance found. There is a blood test that shows that it was in his system at the time. The victim of the single vehicle accident who was driving files a product liability claim, civil claim, against the manufacturer of the vehicle, let's say. And the vehicle manufacturer wants to depose him and say, isn't it true that you were on drugs at the time of the accident, and that's what caused the accident? It wasn't, in other words, the cause was not, related to some type of a vehicle defect or, what have you. What kind of Fifth Amendment rights would that person be able to assert in that claim, in that case there? And this is different than anything we've talked about, because you have a plaintiff in the civil case who could be the subject of possible criminal action. So, there's a TCR, there's a traffic collision report. It evidences the drugs. The guy doesn't know if he's under investigation. I don't think people always know if they're necessarily under investigation. I think you would all agree. And so let's talk just through briefly, if we could, just through that kind of a fact pattern. Would that person have a legitimate right to assert the Fifth Amendment in response, let's say, to a deposition question or a request for admission, admit that you were on this and that's what caused the accident?
I would lead off by saying we're assuming then that no criminal complaint has yet been filed. And in that scenario, I think that a substantial question is going to turn upon the time when that deposition is noticed. And if we're still within, I would say within 3 years of the collision itself, and 3, potentially 6, I think that there is a valid Fifth Amendment interest there.
Okay.
Depending upon the theory that the prosecutor might go with for charging a criminal case, but at least, felony DUI causing injury, and in that scenario, at a minimum, you're dealing with potential liability, dealing with the statement of, well, yeah, you were intoxicated, period, full stop. That is a Fifth Amendment issue, as I see it. Yeah. But again, I think that my answer turns upon, are we still barred by the statute of limitations? Or are we still within the statute of limitations for the criminal case to move forward?
And then if I could take it a step further, Dirk, perhaps you can address this. I guess it even kind of turns to some extent on what kind of drug. If you've got marijuana, which is largely in this state been decriminalized, versus something that's harder like a meth or fentanyl or what have you, that may be a determination as well. Would you guys agree with that, or does that not really matter?
I'm going to disagree with you on that, because I think that our DUI statutes are still broad enough that regardless of what the controlled substance is, yeah, we've taken a sort of more marijuana sort of being regulated in the same way as alcohol. Well, in the same way, you can't drive under the influence of alcohol, you can't drive under the influence of marijuana either. So
Sure.
I think that my analysis does not change depending upon what the drug at issue is.
Okay.
And I guess, Mark, I mean, I would have a different take on that. And I have to say, I can't think of a case that I have seen that directly addresses this, but fortunately, I'm very comfortable speculating. But
What's more
Like all
comfortable than I
lawyers.
am?
my concern would be is some judge saying, yeah, no, you've waived that privilege. You're the plaintiff. You've brought this action. So similar to when you file a legal malpractice case, right? You have a right of privilege. You're waiving that privilege. In this, your attorney-client privilege, all those things become relevant. When you, all of your medical, all your HIPAA and all your medical privacies, you put those in issue, you are waiving those. So in a case like here, where you're the plaintiff, where you're choosing to bring this action, I can see a court saying, you don't have to bring this action. This isn't being compelled. It's not the situation where you're getting sued. It's not like your passenger got hurt and they're suing the company. They're suing the automobile company and you got cross-complained or brought in or whatever it is. And now you're saying, hey, I want no part of this. I got Fifth Amendment concerns about this criminal case. You're the sole plaintiff who has created this issue. And I'm not sure what an appellate court would say, but because judges don't generally like this. I mean, they are not, those civil judges, there is a reading of both Pacer and then Avantes and the other case that's involved in this, where if you really read those cases, you almost should go question by question as to things you can answer and things you can't. I have never had that happen. I've always had judges say, I'm going to stay discovery completely, just because it'd be a discovery referee nightmare to literally have to sit in the room and say that deposition question doesn't have a Fifth Amendment issue. That question does, this question doesn't. So they usually just stay it. But judges are not happy to start staying civil cases. So I think if you were the plaintiff and come into that court and saying, hey, I'm making these allegations, that most trial courts are going to say, okay, well, you need to prosecute this case. And part of that is you answering questions.
I think, Dirk, I think you may be right there. And I'll tell you why, because I think that in addition is that if you're going to talk about a concept in a product liability hypothetical, like I've just given, which is on the civil context, of course, in terms of, causation, there is no more germane a thing in a civil, in this case, product liability case than cause. And if cause could be related to drugs, and the drugs, if this person has brought this and there would be some type of a waiver, those things seem to align to allow that type of discovery over and above the Fifth Amendment, which of course we know is important and it's critical, but there are times when it may not apply. So I think that was a very good answer. I'm looking at the chat box. I don't see anything. If anyone has any questions, we're more than happy to take a couple. We've got a few minutes if anyone's interested. But if not, I just want to thank our panelists and thank you, Ann, and the Bar Association, and also our guests for visiting with us today and listening to our presentation. We had a great time talking about this. I'll tell you, it's very interesting in preparing these types of CLEs. Some of them are just not as interesting as other topics. And I think this was a really interesting topic, at least for us. So we hope that you learned as much as we did. And thanks for being with us. Ann, you probably have some closing remarks, I'm guessing. So if so, then we can wait for those. But if there are any questions, please let us know. I'd be happy to answer any of those. And I don't see any, so I'm gonna assume that our work here is done. So Ann, is there anything else that you'd like to talk about or to lead us out? If you're there.
Hold on, I'm right here.
She's right there. I knew you were there.
I'm clicking my buttons. I'm good. That was really interesting, you guys. Thank you very much for all the wisdom of the collective group here. And I think we're good. Anybody?
Thank you very
No,
much.
having seen no other questions and having no other Mark questions, I think we can call it. And thank you everyone for coming. And have a great rest of your week. And don't forget to register for the MCLE Spectacular.
Register for the spectacular. Absolutely.
All right. Well,
Thank
thank
you
you.
all.
Take care.
everyone. Take care.
Thank you.